So basically my day in and day out is working with businesses, working with employers on just about everything they face with respect to handling employees and different employment laws that affect them. So on the front end, that's helping with policies, handbooks, making sure that they're meeting the legal requirements when it comes to all of those types of things. Troubleshooting when they maybe have an employee that they need to put on a performance improvement plan or unfortunately need to separate employment, kind of handling those calls. And then also when those businesses, or if those businesses are later sued by employees for employment discrimination, wage and hour violations, things along those lines, I defend them in those lawsuits. So my whole job is helping businesses and helping employers to make sure that they're following the laws, they feel supported, and they have us, they're supporting them. One area of my practice that's kind of been developing is where employment and technology meet. And so that lends itself perfectly to website accessibility. And so Jack has done an incredible job talking about the why and just basically everything that we need to know with respect to website accessibility. So what I'm going to try and do is focus just a little bit more on the legal aspects of it, specifically looking at the Americans with Disabilities Act, specifically looking at website accessibility, which I'm so glad Jack talked a lot about documents because that's an important piece as well, and just kind of give the overview of what we're looking at from a litigation standpoint. I know business owners or employers or just anyone hears the word litigation and immediately is like, oh my God, no. It's, part of my job is mitigating the risk of litigation. And so hopefully this will kind of give you an idea of next steps along with what Jack has already discussed. All right, so like I said, I'm going to focus mostly on the Americans with Disabilities Act. And just to give a background on that, again, the Americans with Disabilities Act is a federal law that prohibits or prevents or seeks to prevent discrimination based on disability in various aspects of life. So you'll see that there are multiple titles within that statute. Title I deals with employment. So if you're a business owner and you have employees, Title I of the ADA most likely applies to you. And this is where, if I'm working with employees on ensuring that I provide them reasonable accommodations, ensuring that there's no adverse employment action based on an individual's disability, and those types of questions. Title II deals with state and local governments, again, prohibiting discrimination based on disability and state and local government programming services and things along those lines. And then the main thing that I'm going to talk about today is Title III, which is public accommodations. And so Jack teed that up talking about places of public accommodation and, what that means and what it means with respect to website accessibility. So at this point, we don't have amendments or regulations or statutory language addressing websites yet. We have a lot of great guidance. I'll talk a little bit about that, but we don't have that kind of tangible, what I like as a lawyer, a statute telling me you can do X and you cannot do X, right? And so I want to give you guys a little bit of that framework. But before I do, what is a place of public accommodation? Okay, that is a legally defined term. It's set out in the statute, it's set out in the ADA, and essentially brings up a variety of categories, okay? So it tends to be that most places are places of public accommodation. And so we've got, places of lodging, establishments serving food or drink, places of exhibition or entertainment, places of public gathering, sales or rental establishments. That's one we see a lot with respect to website accessibility questions. So say I own a jewelry store, okay, and I also have an online website. That I'm a place of public accommodation. A few more: service establishments, public transportation terminals, depots or stations. There are also exceptions to some of these terms that I will not bore you with, but if you have a question on whether or not your business actually is a place of public accommodation, we can have that conversation. Places of recreation, places of education, social service center establishments, places of exercise or recreation. So you can see those are broad categories. They cover quite a few different types of businesses. So if your business is deemed a place of public accommodation, you're subject to Title III of the ADA. And as Jack mentioned, that means that you have to ensure that your place of business, both the physical structure and now as well the website, are accessible to all patrons. So that's the focus of website accessibility, making sure your website is accessible to all patrons. And this can come in a variety of different circumstances. I think the most known example is if, like Jack said, if someone is maybe visually impaired and they need to use a screen reader to be able to determine what's on your website, if your website is not coded and set up and developed in a way that the screen reader can read those different sections of the website or can only translate certain portions of the website, your website is not accessible to that individual, again, whether that's in part or in total. Also have examples of closed captions on videos, being able to enlarge or magnify the screen. Again, there's a broad variety of ways that we want to ensure that your website is accessible. And just some common barriers to access. When I present, what I like to do is try and give as many examples as possible, because theoretically this can seem so high level, and especially if tech is not your forte or area, which I totally understand. It can kind of be hard to put this, into practice. But, common barriers to access could be websites, again, that cannot be enlarged or magnified, website with poor color contrast for text, websites that only use color to communicate information. So maybe you have a visual impairment that does not permit you to see that color, and it's denoting something different than another part of the text. It just causes issues for individuals with disabilities who are trying to access your website. Images or photographs that have no alt tags or text, not titling pages. Again, just a few more, blinking or flashing features, portions of website that require a timed response or do not allow a verification of data entered. There are plenty. And I don't say that to scare you. The benefit that we have now is we have so many companies who are able, and individuals who are so knowledgeable in what websites need to be accessible. And like Jack mentioned, we have automated tools to help find these errors. We have, live user audits where individuals with disabilities can go through and say, hey, we've got errors here on your website. They can find these things for you so that way you can remediate. But just to give you an idea of what we're talking about when we say, inaccessible websites or portions thereof. So now the law. This is where I come in, right? So the law is not as clear as I would want it to be. I'm an attorney. I like things black and white, and I think my clients like that too. They don't like the gray area most of the time. And so right now, there's nothing in the Americans with Disabilities Act specifically talking about websites. But for the past 20 years, the Department of Justice has said the ADA applies to websites if you are a place of public accommodation, or in certain circumstances if you're an employer that falls into Title I. 2003, again, announces that websites should be accessible. 2007, we get a few more additional recommendations to, again, what were voluntary guidelines. 2010, they announced they're going to propose a rule, okay, and it's expected in 2015. They push it to 2018. Okay, so we're now getting to 15 plus years after saying you need to make your website accessible, and everyone's saying, okay, what's the standard? And we're missing it. We don't have it. End of 2017, they withdrew the notice of the proposed rule, but announced it has long considered website accessibility part of the ADA. So again, for a while, we've been sitting here knowing that the DOJ believes that websites are subject to the ADA. Businesses are starting to ensure that their websites are meeting those requirements, but we don't have a real standard for them to meet. Fortunately, this year, we have a little bit of one. And I say that because we finally have a proposed rule from the DOJ regarding website accessibility. Now, there's a lot of text on that screen. Apologies for that. And I want to note something about this. This proposed rule from the Department of Justice applies to Title II of the ADA. So if you just remember a few minutes ago, when I was talking about Title II, that's for state and local governments. So this rule is not going to be for places of public accommodation per se. However, if this is what the DOJ is proposing for state and local governments to have to follow with respect to website accessibility, it's an excellent example of what you should try as a business to also meet, okay? Gives us that guidance and that standard that we've been looking for, even if it's not directly applicable to Title III. And so the biggest takeaways is, as Jack mentioned, the DOJ is requiring state and local governments, should this proposed rule pass in this form, I should state that there's a comment period and then it will have to be finalized. But as it's written right now, the state and local governments would need to adopt the WCAG 2.1 Level AA standards. Okay, so it's those those web content consortium, web content accessibility guidelines 2.1 AA, which is kind of the middle tier. There's an A, AA, and AAA. There's exceptions to what kind of content would need to meet those standards. For example, is the rule is proposed right now, archived material on your website may not have to meet those standards. There's a few others, again, just in the form of the rule at this point. It would limit the conforming alternate versions of websites to only when it's not possible to make websites accessible due to technical or legal limitations. So in the past, we would have clients or certain places of public accommodation who would almost set up a separate type of website, if you would, as an alternate form. And it seems like the DOJ is discouraging that unless there's a real reason for it. They really want your website to be able to meet those WCAG guidelines. And compliance is not required where it imposes undue financial and administrative burdens or results in fundamental alteration of the services, programs, or activities of the public entity. So this is interesting. When you look at the ADA with respect to employers and giving reasonable accommodations, an employer does not have to give a reasonable accommodation where doing so would cause an undue hardship or an undue burden for that employer. So when we see this undue financial and administrative burden, it seems to kind of parrot what we see in the employment context of, we expect you to meet this standard unless you can show this undue burden. Now, what a court will define as an undue burden, your guess is as good as mine. But we can know that, we can look at this other case law and other parts of the ADA to try and get a better understanding. Now, the litigation aspect of this. These lawsuits are being filed every day. I mean, there's really no other way to put it. There was approximately 3,200 lawsuits in 2022 alone, which was a 21% increase from the year before. This number has drastically increased every year since 2017. They are normally filed in other jurisdictions, aka not Oklahoma. However, that doesn't mean they're not filed against Oklahoma businesses, okay? A lot of times we have bigger law firms who have attorneys who have made this their kind of niche area, and they file a lot of these lawsuits. And they will file in places like New York, California. I've had cases in Massachusetts, all jurisdictions that tend to have more employee-friendly laws, okay? And so, but just because your business is an Oklahoma business, if your website reaches out and can be accessed by a patron in New York City, for example, they have jurisdiction and can sue you in federal court there, okay? So it can affect Oklahoma businesses. I have seen this firsthand. I have resolved lawsuits on behalf of Oklahoma businesses regarding website accessibility cases brought under Title III. And I say that, again, people hear litigation and they just kind of start freaking out. I don't say that to scare you, but, Jack has done an excellent job of talking about there are so many reasons why now is the time to remediate your website and work on website accessibility. One, that it's just the right thing to do. I will be the first to tell you that. Second, you're missing out on a big portion of business if your website is not accessible to all patrons. And then where I come in is to tell you, and there's legal risk, okay? If you want to avoid lawsuits, if you want to avoid settling, if you want to avoid paying attorneys, which I get is counterproductive to me because that's my job, we need to fix these issues now. Under the ADA, which I should say, these lawsuits are not solely brought under the Americans with Disabilities Act. Most of them are, but there are also state laws that can provide a cause of action for the same type of issue or violation. But under the ADA, the plaintiff who is suing cannot get money damages. However, they can get attorney's fees. So for example, when I have these cases and I have a client who's come to me who says, hey, I've been sued for this. We haven't remediated our website. We need to get this fixed. We have to settle it because they've violated the ADA, which by, inadvertently, lack of knowledge, all of these things happen. You still have to pay those attorney's fees. It can get pretty expensive. You're then paying for my attorney's fees. You're paying for the settlement. You're paying to remediate. Again, all things that we'd like to avoid by working ahead of time to make your website accessible. And like I said, state laws can also provide a cause of action for website inaccessibility issues. And some of those state laws will provide additional monetary damages the plaintiff can receive. So again, that number just keeps going up. As of now, we don't have a Supreme Court ruling on the ADA, website accessibility, their correlation, what it means. We don't have it. Again, it kind of goes to that lack of guidance, but expected to know what to do here. However, circuit courts, so our federal appellate courts right below the Supreme Court, have a few different views of thought. We've got some that say a website is always a place of public accommodation. We have a very few, but a couple that say websites are not places of public accommodation. I would not rely on those because I don't think that's the trend. And we have some people saying, or when I say people, we have some circuits saying websites are places of public accommodation if they have a sufficient nexus to a physical location. So if I have a brick and mortar shop as well as my website selling the same items, it's a place of public accommodation under the ADA. All of that being said, most decisions are in favor of plaintiffs. Again, we've got DOJ guidance saying the ADA applies to website accessibility. I think that's the trend, and I think, dependent upon your risk tolerance, that is something that we need to keep in mind, is that it tends to trend towards websites are places of public accommodation. You need to meet these requirements. One thing that we actually might get clarification on, though, and is a question I get asked all the time, is who is allowed to sue for website inaccessibility issues, okay? There's a lot of conversation about, and I don't love this term, but drive-by plaintiffs, or in the context of websites, surf-by plaintiffs, okay? People that you've never met, that are from a different state, that say that you violated the ADA and your website isn't accessible, and you go online and you go on Pacer and you look, and that person and that attorney have filed 50 of the same lawsuits within a week, okay? That happens. It does. I've had a lot of questions from businesses saying, is that allowed, right? Is that okay? Can they do that? And so what that gets into is a legal question about standing. Who is the right person to bring these types of lawsuits, okay? The Supreme Court is actually, fingers crossed, going to give us some guidance on that this coming term. So they approved this last spring to hear a case called Atchison Hotels v. Lawfer, and they intend to hear this lawsuit on the issue of whether a self-appointed ADA tester has standing to challenge a place of public accommodation's failure to provide disability accessibility information on the website, even if that person does not have any intention of visiting that business, okay? So this is different than if I am a disabled patron and I want to purchase, I use jewelry as an example, I don't know why, but that's what I'm gonna keep using. If I'm a disabled patron, I go online because I'd like to purchase a watch for my spouse, okay? And I'm going to this website to do that. And I'm not able to use that website because it's inaccessible to me. I have standing, right? I went to that website. I intended to use its services. I intended to purchase this item from them, but I could not because of the inaccessibility, okay? When we have some of these other cases where you hear the term tester, they don't have that intention to go to that business, to be a patron of that business, and there's a question about whether or not they can bring these types of lawsuits. So the Supreme Court is actually set to hear oral arguments on this case on October 4th, which is way sooner than I would think. We're almost in October. And so our goal and my hope is that we're going to receive a little bit of clarity on who may sue for website accessibility issues and when, okay? And I want to make clear that I am in no way stating that individuals who bring these types of lawsuits are not doing so for the right reasons. But there have been a lot of legal questions about, that kind of standing question, which again gets into all the legal mumbo jumbo that you just don't need to know or care about who can bring these types of lawsuits. So just know if that's a concern for you, we're hopefully going to get some guidance from the Supreme Court on that that will help us moving forward. So finally, pros and cons, again, making your website accessible, you avoid complaints and lawsuits. I think that's a big one. Potential of more business from impaired users. and just potential of more business from non-impaired users if your website is just easier to navigate. I don't know if you've ever been in a situation where you've tried to use a website and it's just difficult and you're like, you know what, I'm going to go elsewhere for this product. So by working on these accessibility issues, you really have quite a few different positives that come from it. Cons, if you will, is, the cost and time, right? And I think Jack did an excellent job of talking about those three main steps of, doing that evaluation period, figuring what's going on with your website or what's going on with your documents and what needs to be fixed, coming up with that plan and knowing that you don't have to take it all at once. If you want to, excellent, right? But that's going to be different for every business. It's going to be different for your needs. And that's something that you can work on with, within your business, with someone maybe you've hired to help remediate, or as well with counsel. And I think that analysis changes depending on if you have litigation pending, if you've received a demand letter, or things like that. So my advice basically mirrors Jack's. Make those easy fixes and those obvious barriers. The overlays was a great example. Add an accessibility policy to the homepage or non-online alternatives. Again, that policy directing individuals who maybe cannot use your website or need additional assistance, providing that phone number, providing that point person. And if you are creating a new website or if you are updating your website, find a developer who follows those WCAG 2.1 AA guidelines. It's always easier to proactively ensure that your website and new developments on your website are meeting those standards than going back and trying to fix. So if you're already thinking, you know what, I wanted to fix this, this page, or I wanted to add this new feature to our website, and I'm going to get a developer to do that. Make sure you're working with someone who knows about these standards and can ensure that you are meeting them. The last thing I will say that was on that last slide is like I've mentioned earlier, there are so many companies now and individuals who are doing, Jack being one of them, doing great work to help businesses make sure that they are meeting these requirements in a way that fits their business and their business needs. I encourage you to utilize them. And where I come in, to the extent that I can be helpful and a service to you, is working with you to help find reputable remediation services, which we've got an expert here on that too, and also ensuring that you're mitigating later legal risk. Like I've said, I've defended these lawsuits, I've received the demand letters, I've had conversations with plaintiffs' attorneys on them, I've negotiated settlement agreements and know what plaintiffs' attorneys are looking for with respect to terms of settlement agreements. And so that knowledge can help you and feel comfortable that when you're working to fix the issues proactively, you know what those issues may be in the future. So fast and furious, website accessibility and the legal compliance. That's my contact info. If you have any questions, you are welcome to contact me. Like I said, labor and employment is my day in and day out, and this tech side of it has become something that's been really interesting for me. So I appreciate you guys being here today, and that is all from me.